Good morning all, and a warm welcome to our Women in Sectional Title webinar. To those joining us for the very first time today, we really hope that you're going to embrace the opportunity to work together with us, to learn, to share and to grow in this our really exciting industry. Of course, we wouldn't be able to put this webinar together without the assistance of our kind and generous sponsors. Got ZD Fin, Smart Solutions and Finance Solutions for Body Corporate, CIA, Building Insurance Specialists, Meeting Pal, which provides systems for virtual meeting apps, BCM Track, providing innovative software for sectional title schemes, and of course, last but not least, Sectional Title Solutions, who add value to community schemes by utilizing energy efficiencies, smart technology, and advisory services. So thanks again to all of them. Today, we are going to be dealing with a few legal cases, 3 legal cases to be exact, and the beauty about imparting this kind of information to you as chair people, as portfolio managers, as just owners, is that it really provides you with such great certainty. It assists you to go back to owners and say, look, this is what the latest case law says. So we're very excited to be able to impart this knowledge. It just makes it easier for you to understand. I'll be presenting the first case and the last case, and then we've got my colleague and director from our Cape Town office, BBM Law, Simon Thompson, and Zelinda van der Merwe from TVD M Consultants. So you know Zelinda very well. So that'll be in the middle of everything, and I really hope that you come away feeling more knowledgeable and certainly more powerful. All right, so I think let's get started. I'm going to just present and speak. So grab a pen, make some notes, and we will email you a summary of the 2 cases that I'm doing. And I'm sure that Zelinda and Simon will also do the same, just as a summary so that you've got it. So just listen carefully and enjoy the morning. All right, so the first case that we're going to deal with deals with Airbnbs and short-term letting. That massive onslaught at all the coastal units, and it's coming to Joburg, certainly all over the world, where you've got units with value, where people want to come in and short-term let. And the case is called the Body Corporate of the Paddock versus Sally Catherine Nicol. So this is the case that you guys are going to use. It was heard in the Gauteng local division in our High Court, this body corporate is in Sandton, and the judge who presided over the matter was Judge Matsamela. So what you've ultimately got here is Sally Nicol owned Unit 11. She didn't reside in Unit 11, and all the owners of this body corporate became quite anxious about the fact that she was extensively advertising on Airbnb for short-term rental unit number 11, and this was for short-term letting for much less than 6 months, often a day or 2 or a week at a time. So the body corporate went to the Gauteng High Court and requested interdictory relief. So what is an interdict? An interdict is an order to stop you or to compel you to stop doing something. And the interdictory relief sought was that respondent, that is Sally Nicol, be directed to immediately cease from using the unit and leasing the unit for commercial use or as a resort facility or a bed and breakfast. That the respondent, Sally Nicol, be directed to provide copies of the lease agreements that she had with her tenant, and that she be ordered to pay the costs of the court application. So they wanted this kind of thing to stop. She came back fighting, and she said, well, a counter application was brought to say that the conduct rules of the scheme, which were conduct rules 14E and F, were to be made unconstitutional and invalid, were to be declared unconstitutional and invalid, and that she could continue to utilize this as her Airbnb because she made, it was a financial investment and she made a lot of money out of it, and she really wanted to continue. Okay, so what do the conduct rules say? Because obviously we've got to look at the conduct rules, and the judge went to the conduct rules and noticed that, first of all, the conduct rules had been passed by a special resolution, and in fact, the quorum for the special resolution, out of the quorum, every single person had passed that conduct rule. So the resolution was obtained validly. And secondly, the CSOS compliance certificate had been obtained. So that was a really, really good thing. This body corporate of the paddock had all its ducks in a row. So your conduct rules are properly in place and were quite clear. Let me just read you the conduct rules, and you can see that there's no chance of any kind of ambiguity, excuse me. So conduct rule 14E states, excuse me, hold on. Sorry. Right, let's try that again. States that owners are not permitted to utilize their units or lease their units for commercial use without the written consent of the trustees of the applicant, and units may not be used as a resort bed and breakfast facility. Conduct Rule 14F states owners are prohibited from leasing out their units or permitting their units to be leased shorter than 6 months due to security risks to the residents of the applicant. And the owners shall ensure that copies of any lease agreement entered into provided to the managing agent. So you can see that is quite clear. So Sally Nichols said, the rules were unreasonable insofar as they prescribe who may occupy the respondent's unit and on what terms. So it's almost too prescriptive, the rules are. And she said she purchased the unit for investment purposes. And again, she would be severely financially prejudiced in not being able to secure her bond through this payment. Although she knew, by the way, that when she bought into this unit, the conduct rule did exist. So the judge came back and looked at the law. What does the law say? The law says, we all know, Section 10(3) of the Sectional Title Schemes Management Act says that rules must be reasonable and must apply equally and consistently to all owners across the board. And it sounds all very well and good, but how many cases actually hinge on rules and what is reasonable and what isn't reasonable? So listen here to what the judge said. The judge said that the amendment to the conduct rules prohibiting short-term rentals is compliant with the Sectional Title Schemes Management Act, and it's reasonable. And when considering whether a rule is reasonable or not, one has to weigh up the individual owner's interest against that of the body corporate as a whole, and consider the rule against the backdrop of South Africa's laws, as well as the intention of the legislature in drafting the Sectional Title Schemes Management Act. Very important thing that he also said, which I really want you to take and remember. It's important to highlight the freedom of body corporates to regulate themselves. This is the very nature of a scheme, which has its own checks and balances in place in order to ensure that the majority are in favor of the rules which are in the interest of and for the benefit of all members, and which rules have in any event obtained the approval of the Community Schemes Ombud Service. So basically the judge upheld that conduct rule, said the conduct rule was reasonable, it applied to all owners, and therefore you couldn't short-term let a unit at the paddock body corporate. So what did Sally Nichols do? Very feisty lady. She decided to take this on appeal, and she wanted to obtain leave to appeal, also at the Gauteng, in the Gauteng division, and this was in 2021, very recently, and it was denied. So her leave to appeal was denied. The body corporate got the costs in both the original application and in the leave to appeal application. So basically this has now been set. If your conduct rules are in place and the conduct rules are clear, then you are not allowed to allow short-term letting. That ban on short-term letting is okay. Bear in mind, of course, that with the Department of Tourism, short-term letting has been placed sort of within their sphere of power, and we're waiting for them to come back to us to decide how they're going to deal with zoning and short-term letting and that kind of thing. But in the interim, as the position reflects right now, that is the case. So you can whip that out, the body corporate of the paddock versus Sally Catherine Nicol. All right, so the second case now, I'm going to hand over to Simon Thompson and Zelinda van der Merwe. And also, we've got the protagonist over here in the case, Marietta Mineur, which is very exciting as well, to tell us about her victory in court. So I'm going to hand over to you guys. You can take it away from here.
Thank you so much, Marina. I just want to check that everyone can hear me. I'm having a little bit of technical difficulties this morning with my headphones, but in any event. So this was also a very exciting one. I'm always so excited to see how these adjudication orders pan out, because generally speaking, as attorneys or consultants, we give a little bit of advice and then the client goes off and deals with the matter and we never hear from them again. So to have had the opportunity to have been involved from the application right up until the outcome of the appeal was fantastic. So I'm going to hand over to Marietta to tell us a little bit about her personal experience. But first, I wanted to give you a bit of a background as to our involvement. So this was a matter that I took on and assisted Marietta as my client when I was with Professor Graham Paddock at Paddocks. And Marietta came to us as an owner in the sectional title scheme, saying that she wanted to, as Marina said, be the feisty lady and actually attend to this application herself. But because she had never been privy to or party to a CSOS application, she just wanted a little bit of behind the scenes assistance. So we assisted her in putting together the application. We gave her some legal advice. We dealt with the legal opinion that the trustees had obtained themselves. And then, of course, as the CSOS matter unfolded, Marietta represented herself, but we assisted in the background. So just a bit of a background. This matter particularly deals with the change of use of a section. In this specific scenario, the garages in the sectional title scheme were part of the sections according to the registered sectional plans. And because of the holiday nature of a lot of the properties within the scheme, people needed additional accommodation, so residential accommodation. So what they did over the years was converted their garages to additional bedrooms. And then, of course, with that came the problem of not having enough places to park. So people started parking next to their properties. They set up little what do you call them, carports, they paved areas, they parked in the roads, all that fun things. And one can imagine with any type of holiday accommodation, you know, granny comes with, and auntie comes with, and the caravan comes with, and the trailer comes with, and all those fun things. So parking became a problem. Now, we know that when you're going to use your section or an exclusive use area for a different purpose, in other words, from this case, a garage to a residential purpose, that would be a change of use that in terms of the Sectional Title Schemes Management Act needs the written consent of all owners. In this situation, the trustees thought that they knew better and they decided to allow it. And when they went to an attorney for advice, the attorney said to them, because the garage is part of the section, converting it is actually not a change of use. So a change of use doesn't apply to a part of the section, only an entire section or an exclusive use area. They also obtained advice, or took the view rather, that by allowing these conversions of garages to habitable space was actually seen as a reasonably necessary improvement to common property. One can think that's a bit of a strange argument considering that we're dealing with a part of a section here as opposed to common property, but the trustees were put right in that regard. So the trustees called an annual general meeting, and then to add to the injury, they decided to play a little bit of hardball with the notice. They didn't send the notice out correctly, so they didn't send it out via prepaid registered mail with the special business of creation of exclusive use areas and all that fun stuff. So that was a problem. They had incorrect resolutions tabled as part of the agenda. They attempted to create exclusive use areas for additional parking, but giving the trustees the right to determine the location as well as the allocation of the exclusive use area parkings, and we know that that can't be done. They also attempted to push through this reasonably necessary improvement to common property as part of a special resolution. And then to top it all off, if a change of use in fact is applicable, they wanted the owners to give them a blanket approval to actually allow, as time went by, a change of use. So they were trying to cover all their bases, pretty much, went through the act and pick and choose everything they wanted to do, and then lumped it all together in a special resolution that they didn't even table correctly. So Marietta was one of the, I think only, and Marietta can confirm, only owners that knew a little bit better and decided that she was going to fight the cause for the rest of the body corporate. She unfortunately wasn't very well liked, as one can imagine, but off she went to the CSOS, made the application, and when it came to the adjudication time, this was still during the time of face-to-face adjudications, she had advocate Bloch on the other side. And unfortunately, if you look at the order, and I've attached it into the chat function, the adjudication order, as well as the High Court order for Simon, the order was made in May 2018. The adjudicator referenced incorrect provisions of the law. He referred to the Sectional Titles Act. He referred to provisions that don't exist in the Community Schemes Ombud Service Act. I don't believe that he really considered the matter correctly, which obviously opened the door for an appeal. So we believed that the order was incorrect and it was based on an error of law. And with all of my adjudication matters, as soon as it gets very legal, alternatively, if it's going to go the route of an appeal, I refer it to BBM attorneys and to Simon specifically in Cape Town. Simon had a chat with Marietta, and the rest is history. Marietta, would you like to tell the audience a little bit about your experience as the applicant, what you went through, how you found the CSOS proceedings, and of course, what you felt when you received that adjudication order firstly?
Good morning, and can you hear me? Am I there? Thank you for the opportunity. I'll try to make it short. Bailey's is a scheme that wasn't built originally as a sectional title scheme, which makes it very problematic. It never had proper parking. It doesn't have conduct rules to this day, approved conduct rules. So, and I think the CSOS Act is based on the principle that all owners in a scheme will always act in everybody's best interests. That is not the truth. You have your groups of people who simply go rogue, and if you get the right trustees, it becomes a mess. So I saw the CSOS. I attempted extensively to first, of course, engage with the trustees with the aid of Zerlinda, so as to try and keep this out of court. But as this was a purely legal matter, it soon became just a sort of legal argument in the background. I found the CSOS system to be not at all of any assistance in this kind of matter. They took months before they accepted my application. Then again, I was advised at the time that the fact that your application had been accepted does not mean that the process that the opposing party has started is stopped by that. Judge Kluter did disagree with that, fortunately, and I don't know whether that is, that has now become a principle. But anyway, I also applied immediately for an adjudication order, as this was a purely legal matter and not something that lay people could argue amongst themselves. But no, they went with the conciliation process, which I find ludicrous in any kind of situation. I've never found that arguing over the telephone has given any better outcome than arguing in person. So the CSOS situation was simply horrific. At first, they sent me to Cape Town and the body corporate trustees to George. So that's where I turned up, and they turned up in George. So we rescheduled. When I got there, it was immediately clear to me that I believed that the adjudicator and the trustees, the male trustees, had had a bit of a chat. So I stated my case, and they started simply with lambasting me, and it just became sort of an attack on me as a person and not at all anything to do with the case. The Advocate Bloch then proceeded to carry on screaming at me. I thought I was, I don't know, at the Judge Judy adjudication. And when he summed it up and asked me what, the other party never considered any or presented any of the legal arguments. They simply sort of attacked me as a person and my motives for bringing the case. When the adjudicator summed it up, that what I wanted, and I said I wanted written consent from all owners, and he said, so you mean you want a unanimous decision? And I differed from him and said, no, that is not. And he shouted at me that that is a unanimous decision. I knew it was over for me. And the adjudication order was, it concentrated on me apparently as a neighbor from hell, and nothing with the legal matter. So on the day that that adjudication order was sent out to the trustees, I was at Bay Dunes. I don't live there permanently, and I woke up to a toilet roll in front of my door. So that was my situation, but I felt it to be very important, as footfall is very important, especially in a sort of a holiday place where people, I mean, putting 73 new bedrooms there would add about 144 people and 73 more cars. So I could just see big trouble ahead for us, and I decided to persist with this matter because I also heard from friends and other people in especially holiday schemes that they have a huge problem with this conversion of garages. And I'm very glad. I do believe that this is important for sectional title, and that this was an important case to conclude in the courts. I just hope that Judge Kluter's part of the reason why she gave the cost order against the body corporate was that they proceeded with the continued on their route and you know, encouraging people to convert their garages and that, because that is the big frustration. If by the time you ended up in the High Court, or the High Court is concluded, the matter is a moot point, then it is, of course, not of much use. Anything else? I don't want to talk too long.
Thank you, Marietta. That's, you know, I've heard your story before, but every single time I hear it, I can't believe what you went through. And unfortunately, you're not the only applicant or even respondent that deals with things like that at the CSOS. But luckily, this story had a happy ending. Simon, if you want to take us through the next step.
Yeah, I must say, I have never had a client with such courage. The amount of times she phoned me and told me what the body corporate did, and the way she just persisted. She was right. She was showing to be right, but it was not easy for her. And I must say, I really do commend you for the courage you had through this whole matter. But another thing which you did right, which I feel is very important, is that prior to going to CSOS, you got advice, legal advice, and set out your claim very clearly and very succinctly. And I think that was vital. And I think from a lot of CSOS applications, that is such an important step to get your prayers right, because if you go on an appeal, it is one of the first things that a judge will look at. In this particular case, the judge said that the reasoning in the adjudication order was so bad, both parties and the judge said, we're not going to look at the reasoning, but the outcome, that's what we need to deal with. We said the outcome was wrong. The body corporate said the outcome was right, and the matter went from there. Now, this case obviously dealt with the interpretation of section 13(1)(g), change of use, which states just briefly, when the purpose for which a section or exclusive use area is intended to be used is shown expressly or by implication on a registered sectional plan, you may not use or permit that area to be used for any other purpose unless you have the written consent of every other owner within the scheme. Now, the heart of this matter was that section, as well as the main issue was the interpretation of the word section. As Zelinda mentioned, what the body corporate was saying is, the body corporate is only changing a part of a section, not the whole section. And the Act only refers to a section. It doesn't define it as parts of a section, and therefore they're entitled to change a garage into a living area, not because they're not changing the whole section. They try to use a distinction between a utility section as opposed to the primary section. But the judge flat out refused and disagreed with that argument, and I think correctly so. What the judge says was that there is a link between the sectional plan with the section, and so you need to go to the sectional plan to decide how it should be looked at. In this case, it was quite clear that the garage is to be used as a garage and not as living quarters, and it was very clear. Prescribed Management Rule 30F, which is subservient to Section 13(1)G, says that you must look at the sectional plan, whether it can be reasonably inferred from town planning bylaws or the rules of the body corporate, and then the obvious construction, layout, and available amenities of the scheme. So this was all looked at by the judge. What we had said was that the purpose of Section 13(1)G is that you need to prevent owners from changing their sections which will have a negative impact on other owners within the scheme. The judge then came up with a test, and she said that the test is whether or not any change of use will have a material negative effect on other owners within the scheme. Now, I think that's a test which is going to be used going forward in these matters, and I think where issues might come up in the future is on that word materially. And whilst it was quite clear in this case, there was quite a big knock-on effect on all other owners within the scheme, although one person might not affect others. If everybody decided to convert the garage, there would be no space in that scheme whatsoever. But I've had a few instances where clients have phoned me and said, well, so-and-so is storing some boxes in his garage, and that's a change of use. I said, well, do they have a car? No, they don't. So how does it affect you? It doesn't. And if, for example, you store stuff in your garage, but now you have to park on common property, and that creates an issue for other owners, then I think in that instance, it does have a material effect. So I think you've got to be practical. You've got to look at the sectional plan and how it affects other owners. And I think that's where this case is going to be used, on that word materially going forward. I don't know if there's anything else anybody wants to add. Otherwise, back to Marina.
Thank you so much, Simon. Appreciate that. Marietta, hats off to you. You're a strong lady, and we commend you. We really, really do. And I think it's an inspiration for other people, women, men, whoever, but just be strong and don't back down. You know, we won't be dictated to by bullies in sectional title. And at the end of the day, the Sectional Title Schemes Management Act is not a guideline. It's prescriptive. So well done, and great job, Simon and Zelinda. Really, really good. Proud of you both. Okay, so that case was Marietta Manure versus Bay Dunes Body Corporate. You can have a look at it, and we will email everybody copies of summaries of all these cases. Okay, so on to the third and last case, and we're dealing with our favorite subject, pets. Okay, this is CSOS case reference number 736GP117. It's the case of Isak Daniel van Niekerk, and the respondent is against Island Gardens Body Corporate. That's a respondent. It's a body corporate in Centurion. So we're going to Pretoria now. And the adjudicator in this matter is a director at Worksman's Attorneys, Kay Mabazo. So this case actually made it into the news in Australia as well. So we're getting famous here in South Africa. And listen to the facts. So the relief sought in this case by Isak van Niekerk, who is a cat lover, he said in his application at CSOS, I want to keep my kitten on the basis that existing conduct rule is unconstitutional and not binding. I want the rule to be amended based on the principle that rules discriminating against cats and my constitutional rights as a person need to be overturned. Both cats and dogs should be treated equally. Okay, I'm not sure what your views are on that. I don't know if you're cat people or dog people or whoever you are. Me personally, I'm a dog person, but you know, let's see what it said. What did the conduct rules say? What did the owners decide? So the owners decided by special resolution to amend their rules. Initially, their rules did allow for dogs and cats and pets, and it was that usual story. Trustees mustn't withhold unreasonable consent, blah, blah, blah. So then they added and amended a rule by a special resolution, all legally, and they basically said, cats are not allowed. Rule 1.3, cats are not allowed. Cats for which approval has been given may be kept, but not replaced by a cat should they die. The facts were that the respondent brought a kitten onto the scheme and decided to just keep the kitten in the house. The reason why this body corporate amended their conduct rules was because apparently cats had been an issue. There were cats that were eating out of bowls in other people's units. There were cats that there was a cat particularly who went into a little boy's room and sat on the bed. This child was allergic to cats, so that caused a problem. So they had put their minds to the fact and they just made a blanket ban on cats. Again, we always go back to that section 10.3. What does the law say? The law says that rules must be reasonable and must apply equally to and consistently to all owners. Okay. So the adjudicator in this case decided that there was a problem with rule 1.1.3. And he said that it constitutes a complete ban on keeping certain animals. Such a rule has an effect on the use and enjoyment of sections by owners who love such banned animals and renders the rule unreasonable and not of equal application. The order treats cat owners differently from other owners to their prejudice and is set aside with effect immediately. That the CSOS order is served electronically. So as soon as they get that order served, then that kitty cat was allowed to be there. Okay, so I mean, that's quite interesting because I always used to tell my clients that you don't have the right, you don't have a constitutional right to keep a pet. And if owners placed a ban on not keeping animals at all, then that would be upheld. So now we're not sure what's going to happen in the future with regards to bans on cats and dogs. So if you ban everything, cats and dogs, reptiles, snakes, birds, is that okay? Or is it just because of the discriminatory sort of thing here? So I'll read an interesting thing from my colleague in Australia, who we met in New South Wales. And the article says, the world is an exciting place with fascinating differences from country to country. But funnily enough, some things are also strangely the same wherever you go. So it's no surprise that strata pet dramas are playing out internationally, just like they are here, as this recent South African strata dispute and decision illustrate nicely. The strata is obviously Australian for sectional title. And he raised the case in New South Wales. It's a court of appeal case, and it was the Coopers versus the owners. It was like I heard at a tribunal hearing, similar to our CSOS kind of tribunal hearing. And Joanna and Leo Cooper had a little dog where the dogs were prohibited, and there was a blanket ban on pets in the scheme. And the New South Wales Court of Appeal held that under no circumstances could any ban on animals be upheld or allowed. And why did they say that? Well, they utilized basically section 139, which says that no rules could be harsh, obnoxious, or discriminatory. Bylaws, they call them bylaws in Australia. And they said, the Australian judge said, if a bylaw restricts activity, the restriction must protect another owner's ability to enjoy their property rights. So that's really important. I'm going to read that again because sometimes when you're listening, maybe you're not taking it in. If a bylaw restricts activity, so if a bylaw restricts having a pet, the restriction must protect another owner's ability to enjoy their property rights. And he didn't feel that having pets did that. I think managing agents and portfolio managers, I think, might be shaking their heads because very often pets can create big dramas in sectional title units. But they say administrative convenience or certainty for strata buildings doesn't justify restrictive bylaw. Bylaw validity, so conduct rule validity must be considered objectively, not based on individual experiences, beliefs, or knowledge. So you cannot have a blanket ban on pets in New South Wales. We still will have a look in our law soon and see if that's right, but you certainly cannot have a ban on dogs without having a ban on cats, it looks like. So I think that was really, really very interesting. I think at this point in time, we've got quite a bit of time left. So it would be really, really great to open up the floor to questions if we could. And I see that Shanae Cullen asked me a question, just going back to my original case about the paddock. And that question is, what would happen if you allowed Airbnbs and short-term letting, and then all of a sudden you changed the conduct rules to say that you wouldn't allow that? Well, again, I think the judge in that case was quite clear. He sort of upheld that adults have a view in a scheme, and that if you take a special resolution on it at that stage to change or amend something, it doesn't mean that because you've had it there for years and years and years that you still continue to accept it, and maybe you change it. So yeah, I do think that that special resolution would be upheld under the current circumstances. And there may be some kind of sort of adverse inference that's drawn from the fact that you had it in the past, but then, you need to look at what the reasons were for changing that. So I hope that answers your question. Are there any other questions or anything that you'd like to raise in this forum? We're here for you. You've got 3 attorneys, so yeah, go for it. Thanks, Shanae. Anybody else? Lisa, can you see if anybody's raising their hands, or is everybody happy with? Come on, guys, it's not often that you get 3 attorneys in the room at the same time.
Marina, I've got a question. So I just wanted to ask, if you put a blanket ban on the pets, okay, and you say no pets are allowed, but people approach you and they say, look, I've got a special needs, I've got a doctor's letter, and am I allowed to actually get that pet in the complex, providing that I restrict them within the unit, they don't roam anywhere, they don't make a noise, they're not a nuisance to anyone else. What is your take on that based on experience?
Well, Sandy, I think, at the end of the day, we do have that clause in, the model conduct rules, which do allow for assistance dogs without trustee permission. So trustees are deemed to have been, given permission for hearing and assistance dogs. But now, what happens with that? What is an assistance dog? Because then everybody wants to say, Zelinda's nodding her head there, hey, Zelinda. Everybody, in my experience, all of a sudden becomes a psycho and needs dogs for comfort and for, then you've got I know for a fact that there are diabetic people who require assistance dogs who can work out when they're going to need their insulin. So again, it's all going to be based on the facts, I think. Zelinda, do you want to comment? Simon, if you want to chime in at any stage.
Simon's got an interesting one about cats, an adjudication order that also went to the High Court. We recently received a query for an assistance cat. I've never heard of an assistance cat before. I don't believe that, if you're going to simply have a report from a therapist or something that you need an emotional support animal, that would justify. I think it does need to be some type of registered dog. I've never heard of a cat, but a dog, like a seeing eye dog, or like you said, the diabetic, or an epilepsy or something along those lines, that needs a medical certificate. But it's very easy. I only deal with applications where the person's looking for their miniature Maltese poodle to stay in the unit with them because their husband passed away, or it's their only support and things like that, which is very difficult, very challenging.
Yeah, no, I'd agree. It also raises constitutional issues with, if you look at the Bill of Rights and things like that. I think there's a strong argument to be made there. But again, where do you draw the line? Because emotional support might be a bit below the line.
Well, I had a case with an ADHD child as well, and he needed to keep a bulldog. And that case landed up costing his parents probably about thousands of rands, because they brought senior counsel into the case etc. So depends how far you want to go, I suppose. So Leanne Hollington, hi Leanne, you ask what happens when in a state that is an eco estate where they're protecting bird life, etc. Well, we've got plenty of those at the moment, but I think that certainly, I mean, the rules that I'm aware of in terms of conduct rules deal with pets, keeping of pets, you know. So yeah, I'm not sure that that would really relate to protecting bird life, but there's nothing wrong with placing in your conduct rules what you can and can't do in the complex to protect the bird life. I've got a lot of people who also feed pigeons. I don't know, you know, that's not eco state, but that might be their view of protecting bird life. And then you've got, you know, an adjudication which held that you shouldn't be feeding pigeons because it can give you diseases and all sorts of things and that type of thing. Elisabetta, hi, I have a question. Marina, you mentioned that the CSOS certificate was in place in the Paddocks case. What is the position if the CSOS certificate was not issued? Well, I don't think the position would have been any different actually, but I think that it just assisted the case, that the compliance certificate was in place. I'm not sure what the others think there.
Can I take that further?
Please,
Hi, good morning, everyone. Okay, within the governance documents, when the schemes were registered with CSOS, it included all the conduct rules. To date, I know from other managing agents as well, we have not received an acknowledgement of receipt of those rules. So if a matter goes to CSOS, are those rules deemed valid by CSOS? Are those the accepted rules, which were from the deeds office straight to CSOS with the governance document submissions?
Yeah, that's a difficult one, because if it's in process and it's it's the responsibility of CSOS to have put their stamp on, kind of thing. Yeah, difficult. I don't know the answer to that. I don't think that it could be compliant if they haven't looked at it. So yeah, I don't think so, and that is definitely a problem. Please outline, Tina says, please outline the time frame for a CSOS application. Once an application accepted, what is the procedure and time frame in practice? Yeah, well, that's any of the other attorneys want to answer that. You know, how long is a piece of string? Maybe. I think they battle. I mean, with COVID and whatever, it's not easy to say. I've had some CSOS applications that have gone through really, really beautifully in record time, and then others that have been waiting. So it's almost the prioritization of things needs to be looked at. Zelinda, Simon?
Yeah, I found it quite difficult. We've had some cases which have gone through in a month or two, sometimes even weeks, and others where we're still waiting, and it's been 6 months, despite following up, despite emailing, despite physically going to CSOS. We just sometimes struggle with some applications, and to be honest, I'm not sure why. I don't know what they're doing there. I don't know if they allocate it to certain adjudicators who just don't do anything with it, or they're just too busy, or just not going to work and using COVID as an excuse. I'm not sure. It wasn't as bad until COVID started, though. I can't say that. Yeah. COVID's definitely a bit of an excuse at the moment, I think.
Absolutely.
To respond to that, it took 7 months before I ended up in front of the adjudicator. It was a very long and frustrating process. So I don't know why it's different. Can I just say something about on those animals, please? We also have an application now. It's not for an assistance animal, but we require, and is that reasonable? Can I ask, is it reasonable to require an animal to be spayed or neutered, or all animals to be spayed and neutered? Because now this one has a medical certificate that she is, her health is too fragile, this dog. She cannot be spayed because that would put her at risk. So what to do now? It's a fairly large dog as well, a Labrador. So.
Yeah, look, I don't think it's unreasonable at all to ask for the neutering or spaying of dogs. I remember having this conversation with, I don't know if you guys remember the Dr. Platzhund. He was a vet on Radio 702, and he used to be really, really good on these issues. And he used to say it's actually negligence not to spay or neuter dogs in the sectional title scheme. But of course, under these circumstances, if you can bring evidence, then to the table about the merits of a particular situation, then yeah, I don't see them saying no to that. Okay, so sorry, Leanne, I think you wanted to clarify that you wanted to say maybe that with the bird life and that eco state, could cats reasonably not be permitted to be there because of the bird life? Sorry, I misunderstood your question. Yeah, well, I don't know. Maybe we need to go back to the adjudications and look to see what's reasonable. I think, I don't necessarily agree with the pet adjudication, by the way. I'm not sure. I think there are certain circumstances which may render cats more of an issue in complexes than dogs, for example, because you can't really keep them in. But this is what makes for great debate, I suppose. Let's have a look. Is there any last one? Corinne, hello, Corinne. We had a meeting with the new chief ombud who undertook to set up service standards for the CSOS service. This will outline timeframes. It's great to hear. Really, really good. As much as CSOS gets the bad end of the stick every now and then, I think there is a push towards upping service delivery, and hopefully, in the very near future, give them a few years. I truly believe that it would be a world-class service. And the work it's already done in terms of how many mediations and adjudications it's taken on has been great. I think what I'm going to do is we're going to answer those questions. I'll send you some emails to those people who've asked the questions. We're basically running out of time. I would like to say that we are looking at really some great subjects for our July webinar. August is Women's Month, so we're looking forward to setting up many events, and keep an eye open on your social media for what we're planning in August. Thank you very much again, Marietta, Simon, and Zelinda. You've been fantastic today. We appreciate your insights as well. And to our sponsors, ZDFIN, CIA, Meeting Pal, BCM Track and Sectional Title Solutions, thank you again. Really, really, we wouldn't be able to do this without you. So everybody, please take care, keep safe, and stay sectional title savvy. Thank you very, very much.